Legal practitioners are required to conduct themselves with courtesy towards other practitioners and by extension to others that they deal with in their professional practice. Solicitors and barristers, by the very nature of their profession, are often involved in adversarial conflict on behalf of their clients. Courtesy between practitioners allows them to advocate hard without it descending into personal antagonism. Mr. Landers, a solicitor in Canberra, represented a teacher who was being dismissed from the ACT Education Department for medical reasons. He wrote a letter which was, by any standards, aggressive and rude. In it, he said, "In my brief encounters with officers of your agency, they have been rude, unhelpful, obsessive, and compulsive in relation to their own ego and their own self-importance and otherwise unresponsive." There was more, but that's enough to give you a taste. The department complained to the ACT Law Society, which investigated and ultimately found that Mr. Lander had engaged in unsatisfactory professional conduct. He appealed to the full bench of the ACT Supreme Court. The Supreme Court, however, identified the fact that there are two important principles opposing one another here. On the one hand, there's the principle that solicitors ought to conduct themselves with courtesy and without being offensive. On the other hand, however, there's the principle that solicitors and barristers must fearlessly advance their client's cause within their instructions. Their Honours said, if the criticisms the solicitor levelled at the department were true, or at least fair comment as understood in defamation law, it could not be misconduct or unsatisfactory conduct to draw them to the attention of the relevant officers of the department and its minister. That is not an issue with which those considering the statements should have to concern themselves. The fact that it was perceived as discourteous and offensive, even provocative to the parties to whom it is directed, is beside the point. It may well be the case that the choice of confrontation rather than persuasion was not effective advocacy on the part of the solicitor. That is not for us to say. What is important is that it is not unsatisfactory professional conduct to choose a less effective option in representing a client to one which others might choose. This case reminds us that while courtesy is expected of solicitors and barristers, the higher duty is to fearlessly represent a client and their interests.